education seminars on emerging issues in neuroscience. In 2009, the series received a Judicial Education Award from the American Bar Association's Judicial Decisions National Conference of Specialized Court Judges. NCLS also participated in drafting amicus briefs for two important cases which happened in 1997 and 1998. 1997 case was that of Daubert versus Meraldo Pharmaceuticals, and the second case was Daniel Bernstein versus US Department of Commerce. The questions regarding, in the first case, I'll tell you what happened in the first case. Questions regarding the validity of scientific evidence and the credentials of some experts were at the background of the Supreme Court's 1993 decision in Daubert versus Meraldo Pharmaceuticals. I'm talking about the US Supreme Court. The plaintiffs in the lawsuits were two minor children and their parents who claimed that the children's birth defects had been caused by their mother's prenatal use of the anti-nausea drug. The drug was called Bendectin. The complaint was that when the mother was, when the children were conceived, the mother had taken this drug for controlling nausea. The complaint was that that was the cause for, that drug was the direct cause for the congenital defect that the children had. Therefore, the company which, the pharmaceutical company, Doe Pharmaceuticals, which manufactured this drug, was sued. Again, two sets of experts were produced on both sides. One set of experts on the side of the plaintiffs and another set of experts on the side of the pharmaceutical company. Both of them stood to their guns. And you look at the plight of the judge in such a situation. You must remember, the judges are not experts. Even lawyers are not experts in science and technology. We go by what the experts say. What happened was, the Federal District Court granted the defendant a summary judgment. Summary judgment means a judgment for rejection of plaint. We call it rejection of plaint, and in American courts they call it summary judgment. Ruling that the plaintiff's evidence did not meet a standard of general acceptance within the scientific community. Eventually, the Supreme Court was called upon to determine the proper standard for the admissibility of expert scientific testimony in federal trials. This is the first time the question was posed. Take this case as a test case and lay down the principles on which expert evidences could be evaluated by the lower courts. That was the question posed before the American Supreme Court. Then, this American Academy of Advanced Sciences joined with the National Academy of Sciences in filing an amicus curiae brief in that case before the Supreme Court. The purpose of filing this brief was not to comment upon the alleged effect of that medicine called Bendectin on a matter which even the American Association of Advanced Sciences said we have no authenticity for any kind of expert opinion. Even such an association held that we don't have any authentic proof. But they helped the court to lay down certain principles on which expert evidences could be evaluated. The American Academy of Advanced Sciences took a position before the court that courts have the authority and responsibility to exclude expert testimony that is based upon unreliable or misapplied methodologies. That is the most important criteria. And it urged the court to accomplish this task by applying the same criteria that scientists themselves regularly apply in picking and choosing the theories, explanations and methods upon which they build their work. Most of you must have read, about 2 years ago, there was a claim by a Korean scientist about the advances made by him in stem cell research. But subsequently, he had to withdraw that amidst opposition from scientists from UK on the ground that that research was flawed and it was a false claim. Look at where the court will go. Then what happened was, in that case, the court ruled in Daubert case, the Doe Chemicals case, that federal trial judges must act as gatekeepers in order to exclude unreliable evidence from the courtroom. The court stressed that a trial judge may determine whether the reasoning and methodology underlying the testimony is scientifically valid and will assess the trier of fact. Trier of fact is the judge. In urging judges to think like scientists, very difficult. In urging the judges to think like scientists, the court cited this American Academy of Advanced Sciences and NA's brief to the effect that science is not an encyclopedic body of knowledge about the universe. Instead, it represents a process for proposing and refining theoretical explanations about the world that are subject to further testing and refinement. This is the basis on which the American Academy said that the courts will have to analyze the evidence. Then the next case happened in December 1997. Supreme Court issued an opinion in another case which addressed scientific evidence, General Electric Company versus Joyner. Although the central issue in that case was the appropriate standard of appellate review following a trial court's decision to exclude testimony, the court also gave further guidance for reviewing scientific evidence, while Daubert drew a distinction between how an expert draws conclusions, that is the methods employed, and the conclusions themselves. Joyner held that the methodology and conclusions are not entirely distinct and may be considered as linked with each other. That is, if an expert's conclusion is not supported by valid reasoning, it should be excluded. So this is how the law has evolved. Not that we will have to look to the Western countries for any kind of guidance. In fact, if you look for guidance to the Western countries, sometimes it will have the most disastrous effect. I do not know how many of you know about the kind of cases filed and the kind of judgments delivered in the American courts. On the one hand, while we will have to take whatever is rendered by them that would really suit our purposes, there are certain areas where the American courts fail to such an extent that it will be shocking to our conscience. I can tell you one example. In Charlotte, North Carolina, a lawyer purchased a box of very rare and expensive cigars, and he insured them against, among other things, fire. He insured the cigars against fire. Within a month, having smoked his entire stockpile of these great cigars, the lawyer filed a claim against the insurance company. What will you do? Is the insurance claim maintainable? How many of you say the insurance claim is maintainable? How many say it's not maintainable? So only 3% say it's not, 4% say it's not maintainable. Others don't want to vote. You want an expert evidence before you decide. Huh? What happened was, the lawyer stated that the cigars were lost in a series of small fires. The insurance company refused to pay, citing the obvious reason that the man had consumed the cigars in the normal fashion. But you know what happened? Delivering the ruling, the judge agreed with the insurance company that the claim was frivolous. But the judge stated nevertheless that the lawyer held a policy